Yeah, well, yeah. Good evening. I'm Eddie Barnes, zoning administrator for Town of Seven Devils. We will call the Town of Seven Devils Board of Adjustment session into order, 5:30 p.m. So welcome everyone. Our first order of business is going to be to administer the oath of new members to the board and to reappointed members of the board. And our clerk, Hillary Grote, will take care of that for us. So if the new members and the reappointed members will all step up, or just stand up there at your seat and
Come up and
follow Hillary. Come in.
put your left hand on the Bible and raise your right hand. Okay. I
Mark Coverdale, Randy Gilbert, Glenn Morris, Jerry West, Dave Mackel.
do solemnly swear
Do solemnly swear
that I will support and maintain
that I will support and maintain
the Constitution and laws
the Constitution and laws
of the United States
of the United States
and the Constitution and laws
and the Constitution and laws
of North Carolina,
of North Carolina,
not inconsistent therewith,
not inconsistent therewith,
and that I will faithfully discharge
and that I will faithfully discharge
the duties of my office
the duties of my office
as a member of the Board of Adjustment
as a member of the Board of Adjustment
of the Town of Seven Devils.
of the Town of Seven Devils.
So help me God.
So help me God.
If I can get things out real quick. Find your name. We'll have a seat here. I'll pick the chair.
Thank you, ladies and gentlemen. If the regular members would, you want the regular members to go ahead and take the seat now? Or just separate?
We want to do the.
Because I think the regular members will be the ones. Let the regular members just come on up to the,
Yeah, I defer. I thought you wanted to be the chairperson so they could take the stand.
well, I think we need just the regular members to vote on.
Okay, I don't, I defer to you.
Grab some seats up here. Shuffle.
You know, you may have to reshuffle, once the, election of the chair is there. We got a lot of moving parts here. We'll get it worked out.
Thank you.
Thank you, Quinn.
Someone.
We'll get everything organized in the right manner here soon. Okay, so our next order of business will be to, do the roll call for a quorum. Hillary, if you'd like to start the roll call.
Just state your name going around, and then we'll also let the alternate state.
I'm Faye Brock.
Glenn Morris.
Barbara Robry.
Mark Coverdale. Stu Ryan.
Okay, West.
Dave Mackel.
Okay. We do have a quorum of the board. So our next order of business will be to elect the chairperson. So we'll now open nominations for the chairperson for the 2024 Board of Adjustment session.
I would like to consider Quinn Morris, please.
Okay. The nomination for Quinn Morris. Any other nominations? I hear that. Do I have a second for Mr.
Second.
Morris? Okay. And all those in favor, Quinn Morris as being the chairman of the 2024 Board of Adjustment, please raise your right hand. Does it need to state? Okay. All right. Well, Mr. Morris, congratulations. If your barber don't mind, maybe just change the seats there, and I'm gonna turn on.
You two behaviors.
We try to keep them separated. Sorry about all this jostling around here. We're gonna get settled here soon.
Sorry.
Yes, I want some paper up here. I got, thank you.
And change the name place to.
Get you guys straightened out here. All right, everybody else is good here. All right. Mr. Morris, I'll turn the gavel over to you, sir.
Thank you. Just a minute.
Yes, sir. Situated.
Okay, so I think the next item on our agenda is the election of a vice chairperson. So with that, we'll open the floor for nominations for vice chair.
Jim West.
All right, we have a nomination for Jim West. Do we have a second?
I second that.
We have a second.
Mr. Chairman, your vice chair should be among the regular members rather than.
Yeah, oh, yes,
So
yes.
Respectfully, that'd be out of order.
Thank you. It's a pleasure to have you here.
Yeah. It's a pleasure to get to work with you.
Yes.
You made it almost 2 minutes.
I made it almost 2 minutes. All right, so that nomination being out of order, are there other nominations?
Stuart.
I nominate Faye.
I nominate Stuart.
I think I was first.
I think I had recognized Ms. Brock first. So we have a nomination for Mr. Ryan. Is there a second?
Second.
A second?
You did this to me last year. What did you do?
All right, are there other nominations? All right, if not, we'll close nominations. If all those in favor of Mr. Ryan for vice chair, please say aye. Aye. All right, motion passes. All right, so you have in front of you the agenda for today. We'd entertain a motion to adopt the agenda.
Motion to adopt.
All right, we have a motion from member Brock.
Second.
All right, a second from member Coppinow. Is there any discussion? All right, if not, and let's, for the rest of the business, we'll do a roll call vote just to make sure we have everybody, we know exactly everyone's vote. So I'll go down the list. Member Brock?
Faye Brock.
The vote is yes in
Yes.
favor of aye?
Yes.
Okay. Member Irwin?
Yes.
All right, member Morris is aye. Member Coppinow?
Yes.
Aye.
Yes.
All right. Excellent. All right, the agenda is adopted. We do need to, moving now to 7A, approve the minutes of the Board of Adjustment meeting from July 25th, 2023. Those are provided in your agenda packet. If folks need a moment to review those, we can. If you've already had a chance and feel good about them, we could entertain a motion to approve the minutes.
All right, I'll make a motion to approve.
All right, member Ryan has a motion to approve. Is there a second?
Second.
Second by member Hurlbrink. Any discussion? All right, so we will, again, call the roll. Member Brock is aye. Member Hurlbrink?
Aye.
All right, member Morris, aye. Member aye.
Aye.
Brown, aye. All right, so the minutes of the previous meeting are adopted. And now at this time, we will move to new business. So today we have an application for appeal, item 8A. And at this time, we'll open the evidentiary hearing for the application of, or we would entertain a motion to open the evidentiary hearing for the application of appeal. Is there a motion?
Motion.
All right, so moved. Second,
Second.
Member Brock. All right, all in favor, I think we can just say aye here. Aye, all in favor. All right, so we now open the evidentiary hearing for the application of appeal, agenda item 8A. The applicant has requested appeal of a staff decision. The property is located at 603 Thorncliffe Drive in Seven Devils. And the decision, since it is an appeal of a staff decision, is made by a simple majority of the board.
Mr. Chairman, would it be helpful to introduce this issue a little bit, since we have new members who, I'm not sure if any of you have served, or I know two of you at least have served on Board of Adjustment before. I can do a brief introduction, if you will.
That would be excellent. Yes, please do.
Mr. Chairman, I've also provided you with a administrative appeal script for the conduct of the hearing. With this being the first hearing, I'm happy to read through that and run through that on your behalf as the administration of the hearing. However, I'm mindful that I am not a board member and I have no vote and do not want to overstep my role. My role related to these hearings is simply to serve as the advisor to the board. I don't act as an advocate for the staff position and would take no position as to the ultimate findings of fact that you as the board make.
I think given that it's our first meeting, that would be excellent, and maybe subsequent to this meeting, you and I can have some conversations just so you don't have to do all my work for me.
Yes, sir. And
But
I'm happy to do that unless I don't wish to step on your toes.
not at all.
And this board will be called upon generally to consider three different types of hearings. One is an appeal of a staff decision, which is an administrative appeal. The other type of hearing you may have is a special use permit, which is another form of evidentiary hearings. And the third is a variance, which is someone who is seeking an exception to the rules as they otherwise might exist. So those are the three types of hearings you'll be called upon to rule upon. Each of them has a different set of evidentiary rules and standards that you'll be looking at. But for these purposes, I'll focus the discussion on through the administrative hearing approach. The decision comes to you through an appeal by the applicant, Mr. Middleton, and in the case of an administrative appeal, the burden of proof is on the applicant to prove to you beyond a preponderance of the evidence, which is a more likely than not, or sometimes described as a 51% weight standard, as to there being an error in the application of the ordinance to the facts made by the zoning administrator. So that is the standard and the approach for the process. As part of this, all witnesses must be sworn, and the process that we would go through with this is to start, you can start at either place, but generally it makes sense to start with the staff decision and let staff present the facts and rationale for why they believe that there was a violation and why they issued the violation. Have them be at the podium after they testify. The applicant will be given an opportunity to question the witness, and then the board will also be given an opportunity to question the witness. Once we do that, if any of you have served jury duty, you may realize that you have inadvertently signed up for permanent land use jury duty, and thank you for your service. But we'll go another round with the witness to make sure that all questions are answered. Following the staff presentation, any additional staff witnesses they have, they may present, and the applicant then may present evidence to you and call witnesses as needed. You have your agenda packet in front of you. Those exhibits are presumed to be part of the record that you can base your decision on, unless there's an objection otherwise from a party to an item that is in those exhibits. If you receive an objection, those are typically ruled upon by the chair. I'm certainly happy to make a recommendation as to whether the objection should be sustained or overruled, but the initial decision is one made by the chair. If a board member disagrees with the evidentiary ruling of the chair, the board may reconsider that and may overrule the chair by a majority vote as to whatever that evidentiary rule is. Once we go through and present, and you've heard the evidentiary testimony that's been presented before you, it would be appropriate to allow a closing statement, first by staff and then by the applicant. The party who has the burden of proof gets the last word, if you will, as part of the evidentiary hearing. Once you close your evidentiary hearing, it's not appropriate for members of the audience to interject because that begins your deliberation phase. At the start of the deliberation phase, I'll generally give you the standards that which you'll be asked to apply, and then turn the matter over to you folks to discuss the findings of fact as you find them, and to then make a motion. Ultimately, your motion will be one of three things for an administrative decision. You may decide to affirm the decision of the zoning administrator. You may reverse the decision of the zoning administrator, or in certain cases, you may modify the decision of the zoning administrator if you find that it is partially supported by the facts and partially not. So those will be one of the three motions at the end of this hearing you'll be asked to call upon. All of your deliberations have to be in public, but once the deliberation phase begins, you can't ask staff for any additional information or the applicant, or if someone in the audience doesn't like the way that your discussion is going, they can't interject. Your discussions or your deliberations and anything else would be out of order. So before I proceed into our script, I know I've given you a whole lot so far, but are there any questions from members of the board as to anything that I've said so far?
So just to clarify, someone said, in the past, we've held the evidentiary hearing open through the deliberation in case we wanted to ask clarifying questions of any of the parties withstanding. Is that, are you recommending against that?
So you're required to base your decision upon the evidence as a whole from the record that was presented to you. So generally, the gold standard or the preferred method is that the board deliberate and discuss only based upon the evidence that you've received. You can, under certain circumstances, vote to reopen the evidentiary portion of the hearing if need be, but it keeps it much cleaner if you keep one portion evidentiary and the other portion deliberative. So it also makes it easier for me to defend it should this case be appealed, because
that is a not unimportant aspect of what we do.
you will sometimes hear me remark that I do not necessarily care which way you vote. I just don't want to have to listen to the same case twice. So,
We hope that for you as well.
Mr. Barnes, on behalf of staff, do you have any questions as to what I've laid out for the procedures for the board or this? Mr. Griffin, any questions?
Seems straightforward, appreciate that.
Thank you, sir. And Mr. Chair, for benefit of the audience, I will proceed with the opening remarks and then proceed with hearing accordingly. Ladies and gentlemen, a quasi-judicial hearing, much like a court proceeding, is one in which an individual's rights are being determined. Only persons who can demonstrate they will be affected by the outcome of the decision are allowed to participate as parties in the proceeding. Testimony will be limited only to those issues concerning whether the appeal of the zoning administrator should be granted under the zoning ordinance. All persons who speak and participate, including any witnesses that will be called, will be placed under oath. In this matter, the burden of proof is upon the appellant. First, the applicant will present evidence in support of the request. After the applicant's finished presenting evidence and answering questions about the evidence, the board will recognize town staff to present evidence in support of their actions and will answer questions of the parties and the board as to such evidence. Next, anyone who's expressed a desire to be a party and who the board has recognized as a party will then be allowed to present their evidence. All parties will be given an opportunity to ask questions of all other parties and witnesses testifying in the proceeding. The board will be given an opportunity to ask questions as well. After all the evidence is presented, the board will discuss the evidence in the context of the ordinance standards, make findings of fact, draw conclusions, and then make a decision. The board's decision must be made within 30 days of the close of the hearing and must be reduced in writing within 45 days of the hearing. Ladies and gentlemen, a quasi judicial proceeding is being held in the matter of the appeal of Mr. Dan Middleton as 603 Thorncliffe Drive as an administrative appeal of the zoning administrator under the zoning ordinance of the town. Are there any board members who feel they cannot sit as an impartial decision maker in today's proceedings, or any party who objects to any board member hearing this matter? I'll inquire of the board as to, does any board member have a conflict? One of you works for or employs a party to this case. You're related to anybody, any of those kinds of conditions. Any objections from staff to the board hearing the matter? Mr. Middleton, any objection to the board?
No.
Thank you, sir.
Get her going.
Yes, sir. Are there any board members who have received any information concerning this application beyond those which are public record and is part of your packet? If so, please indicate what information you have received so it could be part of our record today. See indications that there are no board members indicating outside information. And are there any individuals who wish to intervene as a party for this action? To intervene as a party, an individual must show special damages related to the application beyond those of concerns of the community as a whole. And that would be to those in the audience. If there is an individual or entity that believes it has standing to participate as a party, we would have to hold a hearing within a hearing as to whether they have standing. Seeing no individuals wishing the floor, I will take that as there's no parties that wish to intervene in this matter. Mr. Chair, I would recommend the board acknowledge the applicant, Mr. Dan Middleton, and staff represented by Eddie Barnes as parties to this proceeding. And all parties and witnesses that the parties wish to call should come forward to the podium so that Ms. Croft can issue the oath and swear them in.
Very well. So, Mr. Barnes and Mr. Middleton, do either of you intend to call any witnesses?
No. Mr. Chairman, if I may, I would just like to state the parties that the staff identified as those having standing.
Very well.
I don't believe any of them are in the audience, but the staff notified by first-class mail on January 10th, 2024, Mr. Daniel Middleton, Mr. David Shinkman, Mr. Stephen Hessman, Mr. Frank Sell, and Alan and Diane Unheim.
And none are present who wish to intervene as a, okay, very good. So Mr. Middleton and Mr. Barnes, if you would come to the podium and the clerk will issue you the oath.
Can you co-swear?
Please raise your right hand. This is a different oath than what we administered earlier. Do you solemnly swear that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. And then put your name and address.
The address here, my address.
Your preference, whatever you feel like you want to use your address.
Whatever address you'd like correspondence sent to, such as a copy of the word.
I'll use 2 lines here.
Whatever you want.
As far as position, resident,
Applicant or owner. Oh, yeah.
Mr. Chair, are you ready to proceed with Thank you, sir. Mr. Barnes, as the representative of staff, be appropriate for you to proceed with your testimony, sir.
Thank you, Mr. Hager. Got supporting documentation for the board.
Possible, do we have a copy for Mr. Eggers and a copy for the?
Yes, the applicants received a copy and.
Okay,
Very good.
Thank you, Mr. Chairman. Eddie Barnes, zoning administrator for the town of Seven Devils. On November 20th, I was informed by Officer Steve Perry that a violation to the town's Unified Development Ordinance had been violated in regards to trees being cut without a permit. Mr. Petty had filled out a police report detailing the incident. And I went to the property at 603 Thorncliffe Drive thereafter, and also did an inspection on the property. I did identify where at least 2 trees had been cut recently. Several had been cut, looked like at an earlier time. And so I did document that. And I then sent a letter to Mr. Middleton. That letter was sent on November 29th. Shortly thereafter, Mr. Middleton had sent me an email inquiry stating that he had gotten the letter, and we had a brief conversation about what had happened on the property. And he did agree that he cut a tree on the property, and he stated that one of the trees that was cut he thought was done by a utility company. And so I went back and looked at that, and that did appear to be plausible. The utility company had maybe cut that. It was under utility line and right next to the street. So I did change the notice of citation and reduced the tree from 2 trees to 1, and the subsequent fine from $2,000 to $1,000. Also in the packet, you will see a copy of Mr. Petty's report. You will see some images that Mr. Petty had taken pictures of there and provided. You'll also see the email correspondence from Mr. Middleton that was received on December 7th. I did talk also with the adjoining property owner who filed the initial police report, Mr. David Shenkman. Mr. Shenkman stated that he did not give permission for the tree to be cut, and that he was upset that the tree was cut. Of course, during the course of this investigation, we did look and see if any permits had been issued to cut trees. The town ordinance does require that prior to any trees over 6 inches in diameter at breast height, that those trees be cut only by permit issued by the town of Seven Devils zoning administrator. Records do not indicate that any permit had been authorized or written for removal of trees at that address. So I've informed Mr. Middleton of the fine and also of his right to appeal. And Mr. Middleton did state that he would like to appeal the violation and the fine. He felt that the fine was excessive, and he was not aware that there was any tree permits that had to be issued by the town of Seven Devils. Once Mr. Middleton had informed me that he wanted to start an appeal, Then I sent a letter, as mentioned, to those parties withstanding on January 10th. And I put a sign on the property notifying the residents of an appeal administrative decision for an evidentiary hearing. And the last part of their packet is the town's ordinance as it applies to tree protection under section 10 of Unified Development Ordinance. It states all trees above 6 inches have to have a permit, and page 61 defines what those fines and penalties are. If I answer any questions that the board may have.
Mr. Barnes, we'll start with the applicant, let him ask questions
Okay.
first before we turn to the board, sir. Mr. Milton, you'll have an opportunity to testify in just a minute. Do you have any questions of Mr. Barnes?
No, it's pretty straightforward.
All right, thank you, sir. Mr. Chairman, do you or members of the board have questions for Mr. Barnes?
So the amount of $1,000,
Yes, sir.
where does that specified dollar amount come from?
Okay, it's a great question, Mr. Morris. The amount is specified in the Town of Seven Devils annual budget ordinance, which is also available on the town's website or here to be picked up in person. The town has placed it inside of the annual operating budget so that there is a change to the fee schedule. There's not a public hearing process you have to go through to amend the ordinance. So that's where the fine is actually stated.
Could we get a copy, we have copies of the other ordinances, would you possibly get a copy of that ordinance to add to the record, just so the record reflects?
Yes,
If you'd like, you're good for it. That'd be excellent, thank you.
yes, sir.
Any other questions?
Yeah, and he said, I'm looking at these notes, that he said, to the officer Petty that he was clearing trees to open a view to Grandfather Mountain, is that correct?
That is correct on the report, sir. Yes, sir.
That is not correct.
Well, that's the report.
That's in the report. That's
So,
what- yes,
so
yes.
I think maybe Mr. Barnes can't testify as to whether or not we can speak to Mr. Middleton when he has an opportunity, but I think it'd be. And I think Mr. Barnes is trying to say that, he can't testify to that.
Yes, sir. Mr. Chairman, that a statement by someone who is not present to testify would be hearsay under the rules of evidence. We're not strictly bound to the rules of evidence as a quasi-judicial proceeding, but it is expected that we should adhere to those as closely as possible in considering evidence. So to the extent that's an objection from Mr. Middleton as to what Officer Petty would state, that objection should be sustained.
I think we'll sustain that, the objection to that, but we do have in evidence.
Well, that's what I was
the
asking.
report of
That's
the officer.
the report that Eddie just handed me.
Yes.
I'm asking if that's correct. In the report.
And those items that you have in your packet, which are not backed by testimony and subject to cross-examination, you should consider that fact as you weigh the weight of the evidence. And that in your deliberations, you'll be asked to weigh your decision based on the quality of the evidence and not necessarily the quantity of the evidence.
Another question. Eddie, has there been a change in the tree policy ordinance? When was the last time it was changed?
The tree ordinance, to my knowledge, has not been changed since it was adopted in 2014, 15, somewhere in that range. The fee has been changed. The previous fine was $500. That was changed in 2022.
Okay, so that's pretty
To
recent.
$1,000, and but in the budget ordinance and taken out in May of this past year, we did an amendment to the ordinance and agreed to take the actual fine out of the ordinance and refer only to the annual operating budget.
Yeah, so that's pretty recent. Hey, another question, I'm sorry. So the fee for the application is $300, correct?
For the appeal.
For the appeal.
Yes, sir.
Is that changed recently also?
The appeal fee has not changed in the last couple of years, to my knowledge.
Okay. Okay, some of the, I have some more about the I was digging around.
The board members have questions?
I do have that. How'd y'all verify the the width of the tree? Did you take measure?
Yeah, generally, we do take measurements. I did go to the property with a measuring tape.
Yes.
And, yeah.
And you
I just measured stumps, all we had to measure by at that point instead of the, breast height is what the ordinance
5
refers
feet.
to.
Something
But,
like that. And there's no way of verifying it if it was, that other tree was a utility, we can't verify that, but it is, you assume that what it looked like.
It was a plausible explanation that the utility company could have cut the tree, due to the service line that it was near, and it was right at the edge of the pavement off Cold Cliffs Drive, so.
And that fine
That fine was-
removed.
that fine's been
It's
removed.
not part of
That is not part of this
the
appeal.
action that's.
That's correct.
Any other questions of Mr. Barnes from the board? So, okay.
How do,
Go ahead, sorry.
I'm sorry,
Yeah.
how do people know that there is a tree removal process?
Well, it's stated in the Unified Development Ordinance, which is all the guidelines for any land use development within the town of Seven Devils. We're Tree City USA, and, we did have a proclamation several years ago. But really, it's, the onus is on the citizens of town of Seven Devils to review any town ordinances for call staff and to see if there's any, regulations as to cutting trees.
They said they would not know this prior.
Yeah, well, they're not sent out any, when it was first adopted, of course, it would have been a public hearing. That public hearing would have detailed, what administrative action was being taken, to adopt the, tree protection, part of the ordinance, of the Unified Development Ordinance. That would have been at a public hearing where anybody could have asked questions or, been advertised and things of that. But since that point in time, it just becomes part of the body of the ordinance. And just like building and finding out what your setbacks may be for a building, you have to go to that ordinance to see what the regulations would be.
Two last questions on that promise. You saw the tree that was cut down, that was being fined, that's being fined, correct?
I saw the stump of the tree that was being cut.
See the tree that was left, was there any tree left over?
There was some remnants of tree. I couldn't identify if it was from that particular tree or not.
So you can't tell if it was diseased or not.
That's correct.
And also, what was the justification for doubling the fine from 500 to 1,200?
That was a town council decision.
Okay. I assume you were there. Okay.
No, hadn't 480 started. Hold on, you're not sworn.
Okay.
Yes, sir.
All right. Good questions for Mr. Barnes? Right.
Mr. Middleton, any follow-up questions from,
No, it's very straightforward. I don't disagree with anything except say.
Mr. Barnes, is there any other evidence for staff?
No, sir. That is all. All the evidence is in the packet has been provided to the board.
Thanks, sir. If you'd like to return to your seat, we'll turn to Mr. Middleton.
Thank you.
Did I speak, Mayor, or do I need to go to the podium?
I'll defer to the chair as to where he'd prefer you be.
It would be preferable just as a matter of order if you come to the podium, but.
All right. First of all, thanks for taking time to hear my appeal. I appreciate y'all taking time in your schedules. My family and I are a 30-year resident at 603 Thorncliffe. My mom and dad bought the house in 1993 or 1994. Of course, my mom and dad have passed since then, and I've taken care of it the last 4 or 5 years. My dad had terminal cancer, and so we saw him through that. And he passed last May, or May a year and a half ago. So in the last year and a half, the house, in the 2 or 3 years that I take care of my dad, the house was neglected a bit. It needed to be pressure washed and painted and gutters cleaned and things like that. So I've been doing that for the last year and a half. I'm trying to get the house back like it was when we all enjoyed it, and with my kids, and so it's a big thing. And I've always been the one who took care of all that kind of thing out there. My dad wasn't much good with tools. He produced blood and swearing, but that was without he was good with tools. So I've been working on the house pretty steadily for a year and a half. We're looking up our front porch. There was a tree leaning about 25 or 30 degrees toward Mr. Shankman's home. Mr. Shankman has almost never been there in the 30 years. We're very regular. We're there a lot of weekends. I've never seen David up there. Maybe I've seen a car there once or twice. We didn't know him, didn't. Saw the tree leaning. There was a lot of dead wood in the top of the tree. And I said, if that thing gets in a strong wind or if it grows a little more and goes over. And I mean, for 30 years, whenever we've had a problem with a tree, we've cut that tree down and we planted trees, we planted river birches and white birches. And so I just was completely unaware that the town had adopted a Tree City USA and all that. So I thought at the time that I went and did what I did, that I was, you know, felling a diseased tree and maybe saving my neighbors from trouble with falling on his deck. When I was out there cutting it, David came on his deck and said, "Hey, what are you doing down there?" I said, "Well, you know, I'm knocking this tree down because it's diseased." He goes, "Well, you know, it's on my property." I said, "Well, I own that house and we own the lot in front of it, and it's pretty close to the line, and I didn't get the survey out, so that is my fault." So he came down and he got his phone out and he showed me the lot lines. I said, "Well, I apologize, you know, I thought I was doing something that would benefit everybody." And he said, "Well, just, you know, no big deal." And I apologized. He said, "No, no need for apology." He said, "Just next time you do something, please contact me and we'll work it out together." I said, "That's fine." And we exchanged, had a nice conversation. I work in European automobiles. He told me he had a Porsche, and I said, "If I can ever help you with it or anything I can do, you know, because I kind of overstepped my bounds here and I stepped on your toes, and I feel bad about that." He said, "No, don't worry about it. No apologies. If you ever need to do anything again, just call me. Here's my information. You know, stay in touch." I said, "Okay, we're done." We shook hands, and I thought it was all done and over. And about 2 or 3 weeks later, I get a letter in the mail indicating that I stepped across some boundaries in the town that I shouldn't have. I said, "Okay, well, I was ignorant of that, and that's not an excuse, but I didn't, you know, do any kind of malice or anything." So I talked with Eddie back and forth a little bit, and he said, "Well, it's pretty cut and dry. You know, you cut the tree, you meant you cut the tree. Here's the policy, so, you know, there you go." I said, "Well, I get it, and I did, you know, I am at fault, but I think $1,000 is, especially with $2,000 was shocking, but we worked that out because I only cut one tree, I promise." And so he said, "Well, you know, you can appeal the decision if you want to." I said, "Well, if that's what I've got to do, it's what I got to do." And I don't have a lot of experience in the courtroom, thank goodness. And so I said, "Well, I'll appeal here." So basically, it's ignorance, which I know isn't a defense, but I was trying to do something which I thought was good for me and my neighbor and the town. And, you know, having been a 30-year resident and paid my taxes faithfully and not caused too much trouble up here, I think maybe there's some room for wiggle. And, you know, if we can find something in the middle, me a culpa, I admit that I did something I shouldn't have done. But $1,000 seems strong, and $300 to come and talk about it, you know, but that's the only avenue I have. So here I am, kind of throwing myself on the mercy of the council. Any questions?
Mr. Barnes, do you have any questions for Mr. Middleton? Mr. Chair, questions from yourself or the board?
I'll start with one, and I think you said this, but I just want to clarify. So you're not disputing any of the facts of the case, okay? And nor are you questioning the interpretation of the ordinance or anything like that. Okay.
Just my concern is the amount of the fine and plus the appeal on top of it. And I'm willing to, you know, pay something that's reasonable. I just think that's excessive.
Mr. Middleton, do you have any other evidence or witnesses you'd like to present?
No, I'm all you got tonight.
Very good. Mr. Chair, it'd be appropriate to proceed with closing statement. Mr. Middleton, if you want to call the chair, we'll call upon Mr. Barnes first for a closing statement, and then let you have the last word, so to
Okay.
speak.
All right, thank you.
If you wish to make one. Mr. Barnes, do you wish to make a closing statement?
Yeah, I would say my interaction with Mr. Middleton has been very cordial. We've had a couple conversations and exchanged emails a few times. You know, don't have any other thing really to add to it, but that's all I have to answer.
No.
Yeah, pretty straightforward.
Mr. Chairman, this would be, I suppose, last call for evidentiary questions. If there are other questions from the board at this point before you proceed to your deliberation phase.
Mr. Middleton, no evidence other than visual of the tree being diseased.
Well, there's a picture of the stump. It's leaning about 30 degrees over and probably the top 20 feet. Hasn't had leaves on it in 3 or 4 years. I'm up here very regularly through all the seasons. And David's a very nice fellow. He's just never ever there. And so, you know, had he been there, I would have gone over and just, you know, discuss with a neighbor. But he lives in Miami, Florida. he told me he was getting ready to move up here, but we had a very cordial conversation afterwards, and I was very surprised to get the letter that this whole thing had started. And I mean, you guys do what you gotta do, I understand that, but I started up with doing what I thought was a good deed, and admittedly somewhat to improve my view, but I figured a dead tree or diseased tree has gotta come down. I just was ignorant of the fact that that policy had changed here.
Further questions from the board? Mr. Chair, at this point, it would be appropriate to close the evidentiary phase of the case and for the board to begin its deliberations and if ready to vote on the case. Again, upon the board beginning its deliberations, it would not be appropriate for the board to receive additional information or evidence from members of the audience. At this point, the board should consider all of the evidence that you have before you, and the question to be voted on by the board will be whether to affirm, modify, or reverse the decision of the zoning administrator. In this matter, the burden of proof is on the applicant to prove that there is an error by the zoning administrator, and the relevant ordinance for consideration is included in your packet under the language relating to tree removal prohibited, which reads, no person, firm, organization, society, association, corporation, or any agent or representative thereof shall directly or indirectly destroy or remove any trees in excess of 6 inches diameter breast height within the zoning district without permission under the provisions of this ordinance. So, Mr. Chair, it would be appropriate for the board to begin its deliberations as to whether the facts as presented to you would support or not support the decision of the zoning administrator. And again, your standard of proof is by the greater weight of the evidence.
So, we would first, and I don't want to do this quite yet because I will ask questions first, but we would first we need a motion to close the evidentiary hearing.
Mr. Chairman, having heard all of the testimony, you as chair can declare the evidentiary portion closed.
Okay, I don't want to do that quite yet.
Yes, sir.
Because my subsequent question is, we did get a copy of the budget ordinance. So for that to be entered into the record for this case, is there?
Yes, sir. I believe that was tendered to you.
Yes,
As
so
part of that and would be considered part of the record.
that is in the record. Okay, I just want to make sure that's in the record. So with that, then we will close the evidentiary and begin our deliberations. Mr. Eggers, as we begin, I want to clarify my understanding, and please correct me if I'm wrong about the discretion that the board has in this case. My understanding would be that we are more or less limited to facts of the case which may be in dispute, which we could resolve, and interpretations of an ordinance if that were brought into question.
Yes, sir. And looking at this under the divisions of government, your role is as the judicial branch of the town, so to speak. So matters that are discretionary would be matters reserved to the town council, such as the amount of fines or whether to pursue fines or not to pursue fines. Those are items that are discretionary and within the authority of the council. The Board of Adjustment's role is to find facts based upon the evidence as you received it and apply that to the ordinance as to what the facts support or do not support. And that is to be done without sympathy or partiality to either party, and also without regard to the consequences as they may be either to the town or to other parties in applying your application of the facts in a judicial role rather than a discretionary role.
Thank you. All right, so with that, we can begin the deliberative portion. Anybody has thoughts they want to share? Or...
Just a quick question to clarify for me. It was when did this new rule, what you want to call it, rule for the trees go into effect? Was it when we became a tree city?
So Mr. Barnes, the evidentiary portion of the hearing is closed.
Oh, I'm sorry.
And as a party to the case, Mr. Barnes can no longer provide that.
Okay.
I did ask him that question. Remember, it was 2004, he said about 2014 when
Yeah,
this,
I didn't write it down.
yeah,
That's why.
he said this ordinance was written, it really has nothing to do with, the ordinance really has nothing to do with Tree City, which is a good thing, but they're separate things.
Okay,
They have the same kind of theme, but 2014, so it really hadn't changed in 9, 10 years.
And the amount of the fine
Has changed.
has changed, so the ordinance itself refers to the current fiscal year budget ordinance for the amount of fines. That has been modified more recently, 2022. It's
Double.
years ago. Yeah, it went from 500 to.
And so did the application. The application's 300, I think that's doubled also. So I mean, to me, the argument, he said he did it, you know, I think the only argument here is what he wants is, you know, is there any leeway on the amount of the fine, which we can just change it if we want to. So that, I think that's kind of the argument here.
Such a change, well, we can't change the amount of the fine. We could, if we ruled that for some reason the interpretation of the ordinance was such that that wasn't the case, but we can't,
I thought he said, sorry.
we could in theory modify the decision
The
of
decision.
the zoning administrator, but not in such a way that,
If you modify the decision of the zoning administrator, it needs to be based upon a finding of fact that would then lead to whatever conclusion would change that. It would not be within the board's authority to modify the fine out of sympathy or concern for the applicant. It has to be based upon the facts as they apply to the board.
Like, for example, originally it was 2,000, but as the facts provided, based on the tree that was probably done by a utility, it changed it to 1,000.
Yes, sir. So if in theory there were two trees that were presented, one of them was not a violation of the ordinance, then that would be what would justify the reduction.
So there's no argument that he admitted he cut it, and the violation is $1,000, so there's no argument there, right? There's no facts in it.
I'm not the finder. I'm not the finder of facts.
I understand that. I'm trying to define how you see that.
right, so the question is to the findings of fact, which I agree with your assessment, and I can do that since I'm on the board. But I agree with your assessment, the facts are not in question. Mr. Middleton admits to having cut down a tree. We have, the zoning administrators provided notice of the citation. It was appealed properly by Mr. Middleton, submitted within the required timeframe. But I see being no dispute of the facts, and also the plain text of the ordinance is, to my mind, clear in this regard. It would be my view that the decision of the zoning administrator be upheld in this case.
I agree with that too. If there's no other, the facts are there, and Eddie presented his case, and I feel for the. Yeah, I do, but it is what the rules are, and we got to.
You accept donations.
Yeah. So, but I guess the argument of the weight of the fine, that's for town council to decide. That's too much, and for the application, it's too much. It's not for the side.
Right, yeah, I think it's certainly outside of our purview to opine on whether the fine is appropriate or not. I mean, the fine is what town council has ruled it is. So with those sort of facts in mind, then entertain a motion, I guess, right, to.
Yes, so you need a motion for one of the three options.
Right, so,
Motion to affirm.
affirm the, right, so we have a motion to affirm the decision of the zoning administrator, in this case, which was a civil fine in the amount of $1,000, based on the ordinance.
Right, and I would second that.
All right, so we have a we have a motion and a second. Is there any discussion on that motion? All right. So we will take the vote on this motion by roll call. So if you state your name and then yea or nay.
Dave Rod, and then for the motion. Bobby Earl Green, yes.
Quinn Morris, yes.
Mark Carpenter, yes.
Stu Ryan, yes.
All right. With that, the motion passes.
Mr. Chairman, procedurally, Mr. Barnes and I will prepare an order that supports your decision and then present that to you for your review and consideration and signature. And then once that is signed, we will send that to Mr. Middleton and any interested parties who requested a copy of that order. And Mr. Chairman, your next order of business would be to either ask for a motion to close this hearing, or you could simply declare this hearing closed, having resolved all matters.
I'll entertain a motion to close the hearing. A motion?
Make a motion.
Motion to close, is there a second?
Second.
Second. All right, all those in favor say aye.
Aye.
Aye. All right, with that, the meeting of the Seven Devils Board of Adjustment is now closed.
Well done, Quinn. First time.
Thank you.
That was a good job.
You know, they say fake it till you make it.
Oh, man, it helps to have someone.
Yeah, I mean, it's sort of hard to screw up when you've got somebody.
Yeah.
Just me. We have to go through the procedure and I get it. It has to be I like where they focus.